Good evening. Welcome to this actually specially jointly hosted session by the Centre for Law and Society in a Global Context and the London Legal History Seminars. So thank you very much to Michael and the London Legal History Seminars for being willing to be a co-host with us. And I hope we co-host very often. We often have, I think, as audiences, interest in the same speakers. So that will continue. I'm really delighted to welcome Dr. Chloe Kennedy from the University of Edinburgh, where she's a lecturer in criminal law and has written broadly on in history and theory of criminal law. I've really enjoyed reading papers on Calvinism, for example, and its influence in Scottish criminal law, and there's a paper I think that's forthcoming, isn't there, in the Edinburgh Law Review on the influence of common sense philosophy on the insanity defence. If you haven't read those, I recommend those very much. And actually welcome her parents this evening as well. So thank you very much for joining us. So it's lovely to have you here. Very much look forward to your talk on a fine source of Wormwood and Aloes, common law crimes and philosophy of Enlightenment Scotland.
Thank you very much, Max, and thank you also to Michael for organising today and the invitation to be here. It's a real pleasure for me. So, as the title indicates, what I'm talking about today is common law crimes in Scotland during the Enlightenment period. Now, one of the interesting things about Scottish law, Scottish criminal law, is we have a large body of common law crimes. There's still the majority of the most, inverted commas, serious offences remain common law offences. And they are regarded as being really quite flexible and capable of adapting to change. This is one of the features of Scottish law that has been really important to its kind of self-understanding. It's the way that Scottish lawyers and Scottish jurists think about the law. So today my main focus is going to be on one of the most striking examples of this feature of Scots criminal law, which is known as the Declaratory Power. Now, the most foundational and authoritative statement of the power is generally thought to be that of Baron Hume. He was an important Scottish jurist who wrote the commentaries on the law of Scotland respecting the description and punishment of crimes, very catchily titled, published in 1797. And he described this power as the inherent power of the Justiciary Court, which is the highest court in Scotland, competently to punish every act which is obviously of a criminal nature, though it be such which in time past has never been the subject of prosecution. So one part of this claim is that the court can punish conduct without having to rely on legislative authority. And this was an ability which Hume thought was particularly specific to Scotland. It was he contrasted it with English law, for example, perhaps wrongly. And a second part of this claim, of course, is that the court can punish acts which have never been prosecuted before. Now, this could mean a new way of committing an existing offence, or it could be an entirely new offence altogether. Now, I mention that distinction because, although it's quite blurry, it's an important one because it's the latter type of situation which poses the most problems. And I say poses because, although since the power kind of emerged or solidified at the end of the 18th century, it or something like it has been used with varying degrees of acknowledgement within recent times, right through to the 21st century. And it's often sparked criticism on the basis of worries over the separation of powers, the likelihood of conflicting judgments arising, and associatedly a lack of certainty within the law. So what I want to do today is think about the way that the declaratory power was understood at the time that it emerged and try and piece together a sense of how it actually would have been understood and how it might have made sense, despite the fact that now we regard it as kind of potentially very arbitrary and problematic. But like I'll say at the end of the talk, I think this also has some contemporary relevance as well as understanding the historical position better. So existing discussions of this power, have tended to focus on the political dimension. This was a power which emerged around the time when some problematic sedition trials took place in the wake of the French Revolution, and the power was associated very closely with these. It was used in those contexts. It was also a time, of course, when Scotland lacked its own parliament. So there were concerns about the potential kind of neglect of Scotland by the Westminster Parliament, and also some more general concerns about the quality of legislation produced at this time. But what I want to focus on today is the philosophical or the intellectual climate of the time that this power came to the fore. And the reason for that is because philosophical thinking at this time was a really inherent part of Scottish culture, public life and university teaching outside of subjects that were obviously philosophical. Maths, all number of subjects were taught by way of a philosophical approach. And lawyers and judges, many of whom would, of course, have attended university, would be therefore familiar with these ideas. But even those who didn't have a university degree would also likely have been familiar with some of the core philosophical ideas of the time, because the faculty of advocates regarded a broad liberal education as something desirable within their candidates. So in many ways, it would actually be quite unsurprising if the philosophical context had not had some bearing on the way that judges and lawyers and jurists thought about the law and practiced. So the way I'm going to try and put this power into context is by looking a bit at Hume's commentaries, what he had to say about the power, trying to situate what he says within a broader understanding of his broader understanding of law, and like I say, the philosophical ideas that you would have been familiar with. But I'm also going to examine some examples of arguments that were used in practice when the court's creative powers were under discussion, to show how these also seem to draw on a stock of philosophical ideas that were prevalent at the time. Now, these arguments are taken from what's known as informations. These were written submissions that were ordered after an oral debate when there was some difficult point of law or relevancy. So they're not actually kind of authoritative statements of law, but they do give us a really nice snapshot of the way that legal thought, how it looked at that time. So these are the kinds of arguments that lawyers were making, presumably in the hope that they would be accepted, and so they can give us a sense of what kinds of ideas were floating around. Now, in terms of works of philosophy, I'm going to be focusing mainly on David Hume, Adam Smith, and John Miller, mainly because their views of justice and morality come out very, well, I think, clearly in the legal sources I'm going to talk about, but also because especially Smith and Miller were not only influential thinkers, but they were also respected educators. So their theories would have been taught to a number of the lawyers who we would be dealing with at this period of time. Now, before I say anything more about the power or ideas of justice or morality at this time, it's helpful to make a few preliminary remarks about the possibility that we might hope to understand this area of law better by drawing on philosophical ideas. And it's here that the title of my presentation becomes relevant. Now, some of you will know the excerpt from the title, A Fine Source of Wormwood and Aloes, is actually taken from a letter from David Hume to Adam Smith in 1759, in which he's expressing his opinion on a recently published work by the lawyer-philosopher Lord Keynes. Now, this work was called Historical Law Tracts, and in it Keynes set out to trace the abstract reason of all laws, and also to try to describe the law of Scotland from its early first rough sketches to its more perfect drafts. Now, I'm going to come back to this idea of conjectural history that's being used here. It's fairly commonplace in Scotland and elsewhere during the 18th century. But for now, I just want to concentrate on Hume's reaction to the work. So what he actually said in his letter was, a man might as well think of making a fine sauce by a mixture of wormwood and aloes as an agreeable composition by joining metaphysics and Scotch law. So he's obviously fairly sceptical about the possibility of doing this. So this view that Scots law and philosophy, or at least a certain kind of philosophy, couldn't be conjoined, seems to have been shared by his nephew, Baron Hume. This is the jurist that I've referred to already, who wrote the commentaries on the law of Scotland, respecting crimes. And we shouldn't really be surprised to see some similarities between the two Humes. They're both called David Hume, which is confusing. That's why I'm calling him Baron Hume when I referred to the jurist. They had a close relationship, and Hume, the uncle, the philosopher, oversaw Baron Hume's education. So in the commentaries, Baron Hume was very clear that he had no intention of bringing forward a philosophical treatise on criminal law, either to try and trace the human history of this branch of law or to give an account of specific offences or punishments based on abstract or universal principles. He didn't want to try and do that. His explanation for why, first of all, was that Keynes had already done the historical part. He referred to Keynes directly. But also, he said that this kind of task really wasn't what he was aiming to do. He was trying to describe the law of Scotland as it actually was. Now, most people, when they read this, they take this to be an indication that Hume was keen to avoid philosophical matters altogether. But I think when we place these comments in the context of some of his other remarks about the nature of law, what it suggests instead is just a reluctance to place too much emphasis on abstract universal theorising. So he gave a series of lectures on Scots law at the University of Edinburgh, and in these he made it clear to his students that he wasn't trying to dismiss any generalising spirit, any aim to try and produce general principles from law. He noted, in fact, this was an important skill for them to develop. And he also did not deny that it would be fruitful to search for some form of universal jurisprudence. Instead, his point was just that the students should try and keep their, what he described as subtle reasoning and generalising spirit in check, because it was important only to use this when the circumstances demanded it. So what I think these comments suggest is that rather than rejecting a union of philosophy and law altogether, he was objecting to over-reliance on a particular type of philosophical thinking, which prioritised subtle reasoning and abstract and universal principles, often at the expense of particular details. So in this regard itself, he had something in common with some of the preeminent Scottish philosophers I have referred to already. According to his uncle Hume, justice, law and government were neither purposively designed nor rationally constructed. Instead, they emerged spontaneously over time through the course of numerous particular decisions and interactions. And this is a view shared by Adam Smith and John Miller as well. So it's important to recognise these philosophers were very different from Baron Hume in the sense that they were trying to provide a universal jurisprudence, which, of course, as I've said, Baron Hume was not trying to do. But what they shared was a regard for particular decisions, the disregard of which they thought had wrongly led some of their predecessors into conflating jurisprudence and ethics. That's something I'll come back to shortly. So connected up with this view of the spontaneous development of law and justice is a distrust of over-speculation, at least when it came to thinking about law prospectively, how law might be developed for the future. And we do well to remember Hume's warning to his students when we notice that, according to Adam Smith, the spirit, what he called the spirit of system, is the hallmark of intellectual arrogance. Okay, and in the realm of law and policy, the best we could hope for would be a kind of piecemeal approach to remedying particular evils when they arose. And again, Hume made similar warnings to this effect to his students, which I won't go into just now. So when we think about the declaratory power specifically, these kinds of deliberations about the relationship between universals and particulars and the limits of speculative reasoning, I think begin to help us understand the power a bit more better. And the reason for that is one of the justifications for the power, at least according to Hume, Baron Hume, was that it would make it possible to effectively repress an evil in its beginnings more effectively than could be accomplished by legislation, which was likely to be partial and defective in its description of new offences. Now, what I've said about worries about legislation at this time coming out of Westminster might make us think that he was just making some remarks about the Westminster Parliament, and he does actually refer to a number of English acts against theft to support his point. But he also specifically contrasts the testimony of experience with the fallacious conjectures of human wisdom before the event. And what he says is that the Scottish way of dealing with crimes gave no reason to envy any other part of Europe in that regard. So clearly there's an emphasis on the wisdom of experience that's important here. Now, this was true also of legislation, according to Smith and Miller. If you wanted to introduce new legislation, you ought to do so with a pre-existing sense of what justice required. So there was clearly a sense of distaste for excessive innovation in law, particularly when it was based on conjecture. But at the same time, there was also an acute awareness of the need for law to be kept in line with changes in society. This is another really key theme at this time, the idea that law had to develop to try and meet the needs of society. And I've mentioned already Lord Kames's historical law tracts. In that, he made a point of connecting up changes in law with developments in forms of subsistence in society. So farming societies, trading societies, these all had different looking systems of law. And other jurists in Scotland and elsewhere in Europe also took this approach. But I think, again, since one of the justifications of the declaratory power was its ability to challenge and quash these evils as they arose, we can see that there's a connection and how it fits with these philosophical works from that period. Now, even though Baron Hume was quite clear he wasn't trying to produce a universal history of any kind, he was also quite adamant that there was a close connection between the criminal law of a society and the manners and tempers and way of thinking at a certain time. And we can see these kinds of ideas also appearing in cases from this period as well. So there's a case from 1808 called Rachel Wright, which concerns a case of child stealing. And according to the prosecutor in this case, it was only with the refinement of society that the wrongfulness of this kind of conduct would actually be capable of detection. Seems like a kind of tenuous link, but that was the way he tried to frame his argument. And likewise, in two really important cases involving combinations of workmen to raise their wages, so basically kind of what we might call striking now, the prosecution claimed that the lack of previous prosecutions or applicable legislation was because it was only recently that Scotland had become a manufacturing nation. So the sense of kind of progress in society needing to lead to a change in laws was a kind of useful rhetorical device. Now, of course, there's a big question about whether the courts are actually the right bodies to be doing this. And some people would, of course, see this as the most fundamental issue with the declaratory power. The question is, why is it the courts are meant to be doing this when, in fact, most of us now would see this as the province of the legislature, the parliament? Now, the people of the 18th century who might argue in favour of courts being the right bodies to do this would find themselves in good company because, as John Cairns has shown, during the 18th century, the previous popular view that law ought to be put on statutory foundations was superseded by a general belief or preference rather for courts as agents of legal change. So there was a generally held, or rather held by many people, view that courts were the appropriate bodies to be doing this. But of course, there's also criticisms at this time as well. There were people who would reject this idea. And one source of criticism was that Scotland was kind of an embarrassment in the sense it had fallen behind other nations like England, particularly, in having fully separated out these two functions of government, this legislative and judicial function. And this criticism became increasingly apparent as the 19th century wore on, possibly showing an awareness of criticisms of judge-made law south of the border. Certainly one article from 1846 shows knowledge of Bentham's work, and so we can maybe suggest a possible connection there. But there was also signs within the works of Smith and Miller as well that the emergence of a legislature to keep in check the judiciary and to complement their work as well was the mark of a civilized nation. So the idea that we should have separate legislative and judicial functions was not particularly new. What's important, though, what's probably more important for today, is where the division of labour was thought to lie. Where was the appropriate boundary between these two functions? And here I think it's where it's really important to understand the meaning of justice and its relationship with expediency, or utility, as it was sometimes called at the time. And the reason for this is that it was the type of conduct which was under consideration, which was a crucial factor in deciding whether it was an appropriate target for judicial or legislative sanction. So there was this qualitative distinction between the types of conduct you were dealing with, which was really important in deciding whether it was something for the courts or the Parliament to tackle. So how did Scottish thinkers at this time conceive of justice? Well, the important thing to note first is that for many of these thinkers, their theories of justice were based on a theory of moral evaluation. And most of the thinkers, at least the ones I'm talking about today, adhered to a form of moral sense theory. According to their versions of this theory, moral distinctions were based on the moral sentiments, the feelings of approval or disapproval that would arise when we considered an action, when we were faced with an action. Now, there are other ways of thinking about this too. Thomas Reid, who was a famous moral philosopher around the time, had a rationalistic sense of the moral sense. He based it on reason instead of sentiments. But despite the variations in these different accounts, one thing that they share is that a focus on the correspondence between individuals. It's a shared notion of morality that was particularly important. And whether that was through the coincidence of sympathy, culminating in the viewpoint of the impartial spectator, as Human Smith described it, or whether that was in the form of a uniformly held moral sense, a moral sense that everybody had and everybody shared and everybody would experience in the same way, it was this commonly held point of view which was important. And another really important thing about justice was, or rather moral evaluation, was its immediacy. The wrongfulness or the approval, whatever the reaction was, would be experienced as soon as we encountered particular conduct. Now, this, according to Smith and Miller, was what distinguished moral evaluation from judgments about utility. So, whereas the wrongfulness of an act would strike us immediately, its remote tendency, its utility, its expediency was a matter of philosophical speculation. If anything, an action's utility would merely strengthen our initial feelings of approval or disapproval after we'd had them. Now, this idea of moral evaluation is important because, as I've said, it underpins most of these philosophers' ideas of justice. But for them, justice was distinct from the other virtues that we might encounter in the sense that it was precise. So while other virtues might be somewhat woolly or uncertain, justice was seen as sharp and clear, and this is what made it enforceable and an appropriate basis for law. And it also was what made it an appropriate basis for punishment. And at this point, it might be worth reminding you that declaratory power is a power to punish. Okay, so that immediately links it up with ideas of justice. Now, unsurprisingly, given what I've said about the connection between punishment and justice, punishment was thought to rest on similar foundations. Okay, so for Adam Smith, the right to punish was based on sympathy. Okay, so this time it's the sympathy, the shared resentment of the person who's been injured. And as with his theory of moral evaluation, any considerations of utility would just serve to back up that feeling of resentment. So they were kind of secondary. It would just strengthen our resolve to punish in cases which were controversial. And Miller had a similar view as well, thinking that these two foundations of resentment and public utility were actually complementary in a sense. We would want to punish And in doing so, we would also be kind of thereby increasing the public utility as well. There was a desire to punish based on resentment, but this, in fact, would actually serve to bolster public utility as well. Now, even Baron Hume, who you'll remember, hopefully, was against the idea of trying to produce a general theory of punishment, he also seems to endorse, albeit kind of obliquely, a similar perspective. So he mentions that laws should be directed at, and I'm quoting here, those crimes which the manners of the age breed a direct abhorrence of, or which the present condition of the people renders particularly hurtful in their consequences to private or public peace. Okay, so he doesn't spell it out, but it seems like Hume is relying on the same combination of abhorrence based on moral feelings and harm to the public. I should have said he actually does have a direct quotation that refers to moral feelings. I didn't just crowbar that in of my own accord. He does. I'm just not going to read the full quotation out. Now, just to be absolutely clear, the writers who discuss this issue located the power to punish injustices with the judiciary. So the courts were the ones who were to punish injustices when they arose. And they were to use spectatorial sympathy when they did so. Now, this comes out really clearly in Adam Smith's work, and he contrasts this aim of punishing injustice with three other, what he describes as great aims of the law, which are police, revenue, and arms. Another one came out later, the law of nations, but they were the three that were connected up, but nevertheless separate to justice. Now, the most important one for today for us is these police laws, because they were designed to punish conduct that threatened the general interests of society, but which did not immediately or directly harm individuals. So they didn't match up with this idea of justice I've just been describing. They were concerned directly with utility, and they were the province of the legislature. So it was the parliament who was to make these police laws that were dealing with kind of pure utility. And Miller, who was very much the inheritor of Smith's work and passed it on to more students when he took up his professorship, he also advocated the same view. So what we can see then is when conduct breached the rules of justice, it was for the court to intervene. And although utility might play a supplementary role, okay, so the punishment might in fact prevent social disorder, this wasn't the goal in itself. When the aim of punishment was pure utility, this was a matter for the legislature. So you can see there's this division based on the type of conduct and why it's being punished that maps on to the split between courts and Parliament. Now, what this meant was when conduct could comfortably be described as a breach of justice, okay, so when it was deplorable according to the precise, easily discernible sentiments of the community or the dictates of moral sense, then there was little controversy about the court using its power to punish. But the further conduct strayed away from this paradigm, and the more its punishment seemed to be based on utility, the more problematic it would seem for the court to exercise its power to punish. And it's exactly this tension which we can see within the cases that I have been looking at. And what you can see in these is that advocates on either side, prosecution or defense advocates, try to frame the conduct in question as falling on one side of the divide or the other, in accordance with what they were trying to argue, of course. And we can also see that the criticism of the declaratory power was at its strongest, its most emphatic, when it's described as violating this distinction between justice and utility. So what I want to do now is just to look at some of these cases that I've been referring to, and point out the ways that these ideas of justice and utility played out in the arguments that were made. So the first case to look at is a case called James Stein from 1786. Now, this involved charges of bribery and corruption to of a revenue officer. So here the prosecutor tried to argue that common law is founded on the principles of common reason and treats of common right and wrong. and it must be plain to the understanding of every man that to corrupt those who one employed in offices of public trust is a crime of a heinous nature, and which therefore at common law must be the subject of prosecution. And he added to this that bribery is evidently a moral wrong. And he contrasted this with statutory offences like usury or smuggling. So with these offences, it would be doubtful whether one could, quoting here, discover from the light of reason alone any impropriety in breaching these laws. But with bribery, every man's conscience must teach him that bribing an official is an act of inherent turpitude. So this clear and universally accessible wrongfulness of the conduct meant it could be punished without express law or statute or any series of judges' cases. And he actually said that the additional injurious consequences of this behaviour just strengthened the case for bringing the prosecution. So it's only there, these problematic consequences are only considered as an additional reason to punish. They're not the kind of foundational reason why we would punish bribery. Now, the defence lawyer trying to challenge this argument relied on a taxonomy of crimes that really, in my view, quite strongly reflects the account of justice and police powers adhered to by Smith and Miller, the account I just outlined for you. So the first category he describes is crimes which, in addition to their own immorality, strike at the existence of society. Okay, so these crimes were punished from the early stages of law's existence, and we don't need to have any written law to punish these kinds of crimes. So here I think we can see the idea of crime as a breach of natural justice, combination of immorality and danger to society that we encountered before in Kames, Smith and Miller's writing. I cut Kames from the shorter version of this, so I'll come back to that if you want. The second category of crimes that the defence lawyer describes were acts that were described by him as leviora mala in se, or lighter evil in themselves. So these types of offences were not punishable at common law, but they could be the object of statutory correction because of the bad consequences to society. So here what we see is when the immorality is not very severe, but the impact on society is fairly large, then it's for the legislature to intervene. The third category of crimes he talks about were crimes which are mala in se, wrong in themselves, but were not punished by the common law because of their, what he describes, small degree of criminality, or the difficulty in making them the subject of judicial discussion. But here I think we can see maybe an allusion to this distinction between justice and ethics I talked about earlier. Only some kinds of morally troubling conduct would be correctly seen as appropriate for law to target. Others would just be seen as a matter of morality. And the final species of crime he talks about were acts that were mala prohibita. So these are acts which are indifferent in themselves. They don't contain such a degree of turpitude as to make them, and this is a quotation, the just objects of punishment, but which, in order to attain or enforce some end of government, some regulation of police, or some object of revenue, are by the force of statute made punishable. So here again, we should note the difference between just punishment and acts being made punishable in the service of some other end of government. Now, the defence lawyer tried to argue that this bribery, corruption of an official, fell into the third or the fourth category, so it shouldn't be punishable. Now, that argument didn't succeed. The indictment was found relevant, but unfortunately, at least as far as I found, we don't have any recorded judicial reasoning for why that was the case. So I can't say for sure why, on what ground that decision was made, but that was the decision. Next, just to speak about the combination cases I referred to before. These are really interesting, or I think they are, because what we see here is advocates drawing on a shared set of jurisprudential ideas, but in different ways and with different outcomes. So in the first case from 1808, the prosecutor effectively tried to argue that the court's powers would extend beyond the limits, as I described earlier, these limits that Smith and Miller talked about. So the core of this advocate's argument was that any injury done to the public intentionally was a crime. Now, I don't have time to really go into the importance of intentionality here, but what you might notice is that the requirement for wrongfulness seems to have dropped out of the picture here. Okay? So the core of his argument is that any injury done to the public is a crime. Now, as you'll remember from the ideas I outlined earlier, this idea of injury to the public was not in itself enough to constitute injustice. So it wouldn't be, according to these theories, enough to ground judicial intervention. Now, this lawyer even went as far as to claim that these acts could be punished solely under the operation of utility, which would change according to our views of the expediency and consequently the criminality of the actions. He also went on to say that the court's jurisdiction shouldn't be limited to simple cases of moral enormity. It should be able to extend to more complicated scenarios, which were perhaps equally profligate and certainly 1,000 times more ruinous to society. And his view was that these shouldn't be spared punishment just because they were complex, they were intricate crimes, or because they were problematic because of remote consequences. He was trying effectively to say that the court's power should go beyond those boundaries I talked about, into the realm of pure utility and remote consequences. Now, this attempt was unsuccessful, and there were lots of reasons given, some of which were economic. We're talking here about conduct which had a direct impact on manufacturing practices of the nation. So there was lots of economic arguments. But one of the main reasons why the libel was held irrelevant, was because it didn't infer that degree of moral turpitude and depravity that renders the conduct relevant for the jurisdiction of this court at common law. So to me, this is a really clear indication that the court was saying, if we don't have inherent wrongfulness, we don't have any grounds to intervene. Now, in the second case from 1811, so this was another combinations case, that came up, the prosecutor tried a different approach. So here what he argued was that a crime is an act that's mischievous to society, so we've got this worry about public utility, but he added that the mischief must not be very remote or obscure. It should be such that ordinary men, if anxious to avoid injury to others, could abstain from doing so. And interestingly, too, what he did was he equated this idea of damage to society to a moral wrong. In his words, he said, if an action be mischievous and manifestly mischievous to society, it must be immoral, unless moral sentiment be grievously perverted, which in this country will not be pretended. And he added to this that the act must be capable of being punished as distinct from the imperfect obligations or duties that were matters of morality and not law. So again, there's this distinction between law and ethics here. So in this case, the approach was, on my reading, to portray the workman's actions as fitting squarely within the parameters of the court's powers, according to prevailing philosophical opinion. There's no allusions to remote consequences, just the simple and easily accessible moral sentiments on which justice was based. Now, in response to this, the defense tried to argue that the combinations of workmen didn't fit this mold. They didn't actually fit this paradigm that was described. He agreed that criminal law was based on the dictates of conscience and simple reason. And he added, too, that where any extension to this law was necessary, this would never become, this is a quotation, so deep, complicated, or extensive that the voice of nature will not always be heard approving of the use which has been made of her original suggestions. He also added that conduct which was undoubtedly criminal, in the criteria that Hume talks about, was that which the heads and hearts of any ordinary man would, after very little reflection, from the mere impulse of common sense and feeling, pronounce to be criminal. So drawing on these familiar ideas about morality and justice, what he did was he contrasted the case against workmen's combinations as being founded purely on political speculation. So he agreed that this is what justice looks like, but he's tried to say that the workmen's actions of colluding together to try and raise their wages was actually, if problematic at all, only problematic on political grounds of speculation. Again, unfortunately, there's not really a huge amount of material, I found anyway, about judicial opinions on this, but we do know that the court was more favourable to the prosecutor here, holding that some relevant material might be selected from the charges to infer punishment, but saying they lacked the clearness and precision and simplicity that was needed for a criminal accusation. And eventually, by a decision in 1813, combinations were held to be crime. This charge of combination was held to be relevant, but this was not without disagreement. When the parameters of this crime were called into question a few years later, the defence advocate argued or continued to refer to this as an artificial offence, and he warned the court not to expand the boundaries of this crime, telling them, "This is not one of those simple crimes which cannot be committed without exciting in the breast both of the criminal and the spectator an instinctive and decided consciousness of its guilt." So this is conduct whose effects were extremely hard to discern and predict, and whose prohibition in previous years, in the earlier case, had, to use his exact phrase, set the court afloat in a sea of mere speculation. So he argued it would be much better if the criminal law books, instead of being loaded up with reasonings that belonged to the legislature, had been allowed to retain some of their obvious morality and primitive plainness. And a really important thing to know is that just 7 years later, by a statute of 1825, combinations of workmen on their own ceased to be a crime. This was by an act of legislation. This was no longer considered a crime. So in a fairly embarrassingly short period of time, practices which the courts had described as dangerous and problematic had been determined by the legislature to be fine and in fact in some ways beneficial. So this unsuccessful foray into the realms of pure expediency by the Justiciary Court was referred to in subsequent cases. This was referred to again, warning, and used to warn the judiciary from trying to do something similar again. So in 1827, when the court had to decide whether killing a man by setting a spring gun was murder, the defence advocate warned them or counselled them to beware of meddling with questions of expediency. And he reminded them their proper remit was just to employ what he described as those judicial lights which disclose laws that already exist. And to told them they couldn't go into the realms of pure expediency without usurping the legislature and admitting that they in fact had no judicial grounds for doing so. Now, I think this chastisement basically conflates two things. It runs together the power of the court to speculate on what we might now describe as matters of public policy, and the power of the court to take cognizance of new crimes. And certainly this was true in the last case I'll refer to today, Bernard Greenhalgh. This is a case that's most famous for having firmly established that the declaratory power exists, because the court decided that in the absence of any previous cases or legislation, it was a crime to open and keep a common gaming house. So they used the declaratory power and said it definitely exists. But it's also famous for the dissent of Lord Cockburn. And I should mention, Cockburn actually was an advocate in a number of the cases that I've been talking about. He accepted that the court might deal with old crimes committed in a new way, so existing offences committed in some new way, or with new facts that fell within the spirit of a previous decision or some established general principle. But he absolutely denied the idea that the court could create new crimes. And that was despite the fact that the justification for doing so was on these two foundations I mentioned before. There was descriptions of immorality and descriptions of potential problematic future consequences. But by this point, those were no longer seen as good grounds for the court punishing. And it's this attitude, I think, of disdain for certainly the more ambitious use of the declaratory power and scepticism towards judicial creativity more generally, broadly speaking, which prevailed from then on. So we might think this was, to some extent, probably inevitable. The 19th century is known as a period when criminal law became increasingly regulatory. More offences were needed to deal with things that weren't immediately immoral or wrongful on their face. And we might question the idea that these are somehow peripheral, but certainly I think we would struggle to say that on their face and the immediate view of the conduct we were dealing with something that was inherently unjust. And I think also there would be questions about whether there are any kind of new affronts to justice that might arise in a relatively mature legal system, as it might be thought about. And also, of course, there's the question of moral pluralism that's seen as part of modernity. We might doubt our ability to reach the level of consensus required to decide that something is actually morally wrongful. And certainly we might also question the ability of judges and even jurors to accurately channel the sentiments of a community. And on top of all these factors, as I've already mentioned, in the 19th century, there was growing criticism, of course, of judge-made laws, most famously by Bentham and Austen, and an acceptance of a split between legislative and judicial powers on a more functional basis between lawmaking and law interpreting. Now, I think, notwithstanding those factors and those changes, there are some more contemporary issues that this discussion I've outlined today resonates with. So one reason is because in Scotland, despite the fact that the declaratory power is seldom invoked explicitly, like I said, the idea of flexibility is still a huge part of the law as it's practiced and also the way it's understood. It's seen as a defining feature of Scots law. But what's interesting with the newer cases is what's most commonly relied on is the idea that the conduct is punishable on some pre-existing general principle. So that's obviously different than claiming the ability to punish without any precedent whatsoever. But judges have continued to say that they have the power to do so. But despite this change in emphasis towards general principles and away from the more contentious use of the power, like I've said, these decisions continue to attract criticism for undermining the separation of powers, undermining legal certainty, giving the judiciary too much discretion. And I think this criticism touches on some more general issues regarding our expectations of law now and what we take to be a theoretically informed legal system and how it should look. And this is because the discussion I've outlined goes to the heart of a debate between those who would see principles as a valid source of law in addition to precedents and statutes, and those who are less inclined to do so. And it also goes to the heart of the debate between those who see judges' determinations as being right or wrong purely on the basis of their authority, rather than in accordance with something beyond this, some sense of right or wrong which transcends the judge's authority to make the decision. So in some ways we can see the early discussion about the declaratory power as a kind of an analogue of this contemporary debate. And I don't think it's any coincidence that one discussant of this more expansive view of adjudication that relies on general principles, Neil McCormack, draws explicitly on Adam Smith's theory of moral sentiments. He talks about that and wants to model some of his theories on that basis. But I think a really important difference, I'm finishing up soon, the very important difference is that while the Scottish Enlightenment thinkers were dealing with an idea of justice that didn't depend wholly on legal considerations, like I said, it's to do with this link between society and law that was really important. Contemporary advocates of adjudication on the basis of principles would restrict those principles to ones from within law. Okay, so the modern declaratory power style cases, the ones that are more recent examples of something like the declaratory power, fall somewhere between these two approaches. Decisions to expand the law have been justified on the basis that it meets the needs of the community, but also because it fits with some pre-existing protected value, some value the law protects. So, for example, preventing frauds or violations of the rights of others. Now, this latter justification, the idea that of protecting one of law's values, is quite similar to the notion of legal principles advanced by contemporary theorists, according to whom it's acceptable for judges to interpret in accordance with principles inherent in law, such as not harming people, respecting others, those kinds of things. And when principles are drawn this broadly, when they're defined that widely, I think it's quite difficult to see the difference between cases where you are building on law or an existing principle and cases where you're outright innovating, you're creating laws, crimes. So the very last thing I'll say is that I think another thing we should bear in mind from this discussion is the importance of unintended consequences and the limits of abstract reasoning. And, we can see this playing out in contemporary discussions about the value of theories that are really abstract, but claim nevertheless to talk about the realities of legal practice. They don't pay sufficient attention to the institutional and historical context. So I think there are some relevant factors that feed into contemporary debates that are underpinned in the declaratory power. So thank you very much for your attention.